heard appeal in the matter of FCC Buckinghamshire Ltd and Buckinghamshire Council.
Mr. Watt. Good morning, my lords. I was yesterday, at the time we broke, I was just taking the court through how the dispute arose post-contract. And we looked at the North London Waste Authority third-party waste contract and the comparison of the rates paid by the third party and those paid into the project. If we could just look at the same, the document we had was Miss Gillian Sinclair's slides, which are in the supplementary bundle at tab 46.
Yeah.
And I just wanted to, I hadn't already just flagged up, so that the three contracts, obviously North London, which is the subject of the gold paper and the email we looked at, Luton, where the rate paid by the third party is the same as the guaranteed rate, so that there is no income share there either. And then the third party waste contract is with Hertfordshire, and that summary, Miss Sinclair's summary is at page 927. And the rate that the third party has agreed to pay is £89, whereas the rate that FCCR or FCCB will receive is £77.69. So that of these three huge third-party waste contracts, the total third-party waste TPI that's going to be shared is, I can't quite do the maths, but 75% of it is £1.29. So in summary, two third parties are paying significantly higher than the guaranteed rate, but all of the profit is being retained within FCC. And on the third, Luton, the rate paid is in fact the guaranteed rate. And we would tentatively suggest that, as referenced in the documents in the bundle, that £89 or £90 represents a market rate, and the guaranteed rate is obviously significantly lower, and it's lower because we, the Buckinghamshire Council, have in effect paid for or paid 85% of the cost of this facility. Yesterday, when looking at the North London Waste Authority contract, my learned friends sought to identify various costs or risks that FCC Waste Services, or FCCW as you refer to it, were taking on, and that therefore they were entitled to a bigger rate. And she did that by reference to the contract between FCC Waste Services and FCCR, that's at tab 11 of the supplementary bundle, page 389. This contract at 389, it's dated the 9th of December 14, but it was the evidence at trial that it was actually post-date, it was backdated. So when FCC came to do their presentation in March 15, they needed this contract to justify what they were doing. They backdated it to December 14. And at 397, you can see who signed the document on behalf of the two companies. And the first signatory is Mr. Vicente Ortiz, who gave evidence. He was the company secretary at the time. And his for reference, his cross-examination is in tab, an extract of his cross-examination is at tab 23 of the supplementary bundle. And an extract from his witness statement is at tab 21. And what that evidence showed was that he was acting for both parties. So it's an FCC, it's not an arm's length transaction, I suggest. It was the same individual acting in FCC's interest. And FCC's interests were served by a rate that paid as little as possible into the project, hence the agreement of 75.97. So the rates at page 392. And I think my learned friend took the cork to clause 5, which deals with rejected waste. She made the point that, well, FCC Waste Services have got this risk of non-compliant waste. And that argument, I believe, was also made in 2021. And the answer to it is, no, this is just a pass-through. The risk of non-compliant waste, as one would expect, is with the third party. If you look at the actual agreement with the third party, which is the previous tab 10, starting at 347, the relevant provision is at bundle page 380. (11.2) The contractor will use reasonable endeavours to segregate contract waste which cannot be accepted at the treatment or disposal facility. So the contractor in this contract is notionally FCC Waste Services. It's obviously going to be FCCB or FCCR as the operator of Great Moor that's going to be doing this. So we say, where this takes you is that there's no additional cost involved. You have very simply a third party paying a higher rate into the project, but FCC trying to keep that premium and arranging things so that FCCR receives only the guaranteed rate. If I can move on from, so those are the 3 third-party waste contracts. If I can now address, before coming to the individual points of appeal, if I can just address the different types of costs.
Different types of
cost that are relied upon by FCC. And in doing so, I will inevitably stray into the directly incurred issue and proviso A, but it's helpful just to identify what these are. We say there are essentially 3 types of cost, and they are central office overhead, so the head office in Madrid and so on, local overhead type costs, such as buildings, depreciation, insurance, and so on, and then haulage costs. And we've always accepted, I think, that haulage costs are directly incurred costs. The complexities within local overhead, you've got manpower costs, and we acknowledge that manpower could be a mixture of directly incurred and not directly incurred. My learned friend's characterisation, just for reference, it's paragraph 35, at core bundle, page 1090. I think she refers to the second category as local operational costs. But as it were, the local costs are obviously a mixture of things like insurance and buildings and manpower. Now, if we just see how these costs were presented, my lords, yesterday my learned friend handed out or provided an enlarged version of page 250. But when I came to study it, the piece of paper had got larger, but the font appeared to be the same size, but now on a landscape. So my learned junior, Mr. Millen, has had another go, and we've handed up in a bigger font, so it's just slightly easier to read. And, I don't know if my lords have got. It should be BC extract of core bundle pages 254 to 256.
Yes, I see.
Now, just to make clear, if it wasn't clear yesterday, this is material prepared by FCC. This is how they presented it. But we appended it to our particulars of claim. So it's called Appendix A of our particulars of claim, because we were the ones challenging these costs. But it's there, formulation and presentation and so on. And this particular example is North Hearts. Of equivalent information was provided for North London Waste Authority. And our complaint during the litigation was, when you look at, for example, manpower, which is about halfway down the page, there's a list of costs which are numbered, and it's item 3. We just get a description, manpower, followed by sums of money. And that wasn't hugely helpful. The other costs, or in each case, appear to be in the nature of overhead type costs or local overhead type costs. Now, yesterday, my learned friend made a number of submissions about the costs and the evidence of those costs that we just want to correct. The main point was that we were happy with the material that was provided. We were not at all happy. If I can just take the court to the correspondence in the supplementary bundle at tab 26.
Are we coming back to the spreadsheets?
We will do, my lord, but it should just be one page that we were going to look at.
Yeah.
We're starting with that spreadsheet, my lord, so that one can see how the defendant presented it in principle. As my learned friend explained to the court, there was then the sampling protocol, which went on for many months. And we found that process extremely unsatisfactory. The court will have in mind that obviously what the defendant was doing was explaining their costs by reference to the entirety of costs, and then trying to apportion costs to TPI. At page 688, tab 26 of the supplementary bundle, we agreed the values as values, subject to 3 exceptions. At paragraph 3 of our letter, of my instructor solicitor's letter, Buckinghamshire Council makes this concession reluctantly and in circumstances where the entire calculation of TPI appears to have been carried out by the defendant retrospectively, long after the event. There are numerous discrepancies. In general, item 3.3, in general, the information provided is inadequate and poorly presented. At this stage, the defendant was seeking to adjourn the trial in April 24, and it was imperative for my client that the trial was not adjourned. And so we limited ourselves to the points of contractual principle, as it were. But we spelt out in this letter that we were not accepting that these costs were deductible under the definition and so on. The impression my learned friend sought to give yesterday was that these were neatly collated costs that were easy to follow, that arose specifically out of these contracts, and that's absolutely very far from the case. My learned friend specifically said yesterday that the software stores costs specific to each contract, that we were able to see contracts of employment, that we could look at their computers, and in particular that it was possible to identify precise costs arising from individual contracts. If that were the case, much of the dispute would have been resolved, one anticipates. In practice, there were 2 fundamental problems. The first one is that the costs that we were looking at are shared across multiple projects. And that has obvious implications given the definition of third-party income. And secondly, there was a specific problem with manpower. If I could just expand on those 2 points. So if my lords turn up Mr. Mackenzie's witness statement, which is at tab 18 of the supplementary bundle. So this is now the chief financial officer for FCC Group, I think. FCC Environment UK. And he had prepared the spreadsheet that we've just had there, although he obviously didn't call it Appendix A as a particular claim. So he explains, there's various passages where he's explaining what's going on, but if I can take the court to an example, at 574, he's describing the exercise he did after we had essentially won in front of Mrs. Justice O'Farrell, and the court had upheld our right to income other than just what was paid into the project. And at 5.1, Mr. Mackenzie said, the additional TPI calculations were prepared for each of the sites that had been identified as supplying waste to Great Moor. The calculations are based on actual data from the specific cost centres for each site, based on the management account, profit and loss. So it's not based on audited accounts, based on management accounts, specific to cost centres. The problem that arises is that the cost centres don't correspond with the contract. So there's this fairly nightmarish extrapolation exercise that had to be done. Mr. Mackenzie goes on with the full revenue and cost information, and by apportioning the relevant costs according to volumes of waste that were actually delivered from each site to Great Moor on a month-by-month basis. This was generally based on average cost per tonne calculations. This was the most logical method by which we could construct the additional TPI calculations that were required by the court order. The court order itself did not prescribe how we would go about preparing additional TPI calculations. So the problem that's arisen is the defendant wasn't keeping a record of specifically and solely incurred costs or directly incurred costs to deduct from TPI, because until Mrs. Justice O'Farrell's decision, they didn't believe they had any need to deduct costs because they didn't believe that any of the income they were generating was third-party income. Mrs. Justice O'Farrell found against them, and that then required them to retrospectively. Mrs. Justice O'Farrell's decision was in 2021. The project had been running since 2016. Retrospectively, Mr. Mackenzie had to somehow find costs. And as he has explained at 5.1, that was not, as my learned friend suggested, simply a question of going to the computer and pressing print. It was a matter of looking at different cost centres which fed waste to Great Moor and other venues, and in Mr. Mackenzie's evidence, doing this apportionment exercise. And then if we look at an example of how that went, to take an obvious example of insurance, where we say, well, that doesn't satisfy the directly incurred or proviso A. If we look at the cross-examination of Mr. Mackenzie at tab 24, if we slightly jump into the middle of it in order to save time, but at page 644, I'm asking Mr. Mackenzie about his method of apportionment. And I put to him internal page 153 of the transfer, line 3. What you're doing is dividing the cost of operating that transfer station.
Sorry, I wasn't keeping up. Where are you?
I'm so sorry. I'm on page 644 of the bundle,
Yep.
supplementary bundle, page 153, so top left-hand quarter.
Oh, I see, yes.
Line 3.
Yep.
What you're doing, you being Mr. Mackenzie in that statement, what you're doing is dividing the cost of operating the transfer station by the number of total tonnes and doing a pro rata apportionment to say what part of the cost should be to my client's account. Agreed? That's what we did, yes, in general terms. And then I explained, I meant, in other words, my client's account being the deduction from third-party income. That's going to be, for that apportionment, line 13, for the apportionment process, obviously there will be some costs which are in the nature of fixed costs, allowances or provisions, where the apportionment is a very theoretical exercise. Is it fair? Mr. Mackenzie, most of the exercise is theoretical, because there was no prescribed process. Now I clarify what I mean by theoretical. I gave the first example of a lorry, a haulage example, where there is a proportionate, one would expect a proportionate relationship between waste quantities and cost, because the main cost is going to be fuel. And then page 154, line 2, at the other extreme, if you have, for example, the insurance of a waste transfer station, that is unlikely to be proportionate to how much waste that transfer station is taking, or indeed if it has any waste. And Mr. Mackenzie challenged that because he said in his internal FCC world, they do indeed allocate insurance according to quantities of waste. But in terms of the external cost, so I clarify at line 17, we're at cross purposes, it's my fault. I think what I meant was from the insurer's perspective, when you insure a waste transfer station, I don't imagine the insurer says, well, exactly how much waste. And Mr. Mackenzie replies, they couldn't care less how much waste it's a building. That's what I'm getting at. So, proper 155, correct. So, for those overhead type costs, there is absolutely no relationship between the waste and the cost. It's not an incremental cost, it's not a marginal cost, it's not a direct cost, it's not solely and specifically incurred, generating income. It's simply a cost that FCC has. And what Mr. Mackenzie has done, at great effort, is to work out an apportion of that we should bear. And we say, and that's true for all of the costs, with the exception of haulage. Sorry. What Mr. Mackenzie did for head office overhead is to calculate a percentage against revenue. What he did for all of the other costs was just apportionment exercise. And we say, well, you can understand that with haulage, because haulage is indeed going to be proportionate to the distance carried and the quantity of waste, but it's not going to be true for any of these other costs. One has a waste transfer station. That's an established facility. Whether a lot of waste is going through it or none, the costs are essentially the same. And the judge adopted that approach when dealing with the converse argument, where a waste transfer station is not used. So if we can just turn up the judgment, which is tab 10 of the full bundle. And it's page 224, where he's dealing with our arguments about the meaning of provisos B and C. And as we'll see when we come to haulage, the point that arises is that FCCB do not use...
Have you got the paragraph? I'm sorry.
Paragraph, no.
I'm so sorry, my lord. So we're at page 125 of the bundle, paragraph 224.
Okay.
I was just going to explain what the judge was addressing here. So he's addressing our argument that in relation to provisos C and B, there is an apparent anomaly in that we pay for waste transfer station at High Heavens and compensation for Amersham that FCCB does not use for third-party waste. So we're paying them literally millions of pounds for the operation of the waste transfer station, compensation for not having Amersham, and haulage between waste transfer station and Greatmoor. And
Sorry, can you just say all this again?
I'm so sorry, my lord. So the anomaly that arises, as my learned friend explained, originally there were going to be two waste transfer stations as part of the facilities. Through the base case, we were going to pay for the operation of those two waste transfer stations. And also haulage of third-party waste to Greatmoor. And the contractor's case, accepted by the court, is the haulage we were paying for was from those waste transfer stations to Greatmoor.
Yeah.
So that's High Heavens and what would have been Amersham in the event we paid compensation for not having Amersham, but the argument remains the same. What's actually happened, my learned friend took the court to the geography of it and showed where the various transfer stations that were actually used are. What's actually happened is FCCB or its affiliates have used other transfer stations within the operation of the SEC group for the supply of third-party waste to Greatmoor, whilst we continue to pay, or whilst the base case model still allows for the cost of High Heavens. And the anomaly that arises is, well, we're paying through the payment, through the calculation of unitary charges, we're paying millions of pounds for High Heavens to deal with third-party waste. You are seeking to charge us for other waste transfer stations performing precisely the same function. And of course, the quantities of waste are not the same, we accept. In both cases, it's tens of thousands of tonnes per year. But our case, for the purposes of our haulage appeal, is whether the quantities are the same or different, that's a risk that the contractor took. In dealing with that argument, the judge made the comment at paragraph 224 that High Heavens was still being used for contract waste. So FCC couldn't close it, they couldn't not use it. And then he made this remark at the end of 224, there is no evidence that any or any significant costs would be saved at the waste transfer stations, given that they would have to be kept open for contract waste, even if third-party waste was diverted elsewhere for handling. And our point is, yes, but that's obviously right generally, leaving haulage to one side, which is a marginal incremental cost. How much it costs to run a waste transfer station is almost entirely independent of what quantity of waste is going through it. That's no more than the reflection of Mr. Mackenzie's evidence. He's stacked up these costs against TPI on an apportionment basis without any regard to what additional cost or what marginal cost or what cost of stolen specifically. So that's the first problem with the way in which the costs have been presented. It's an apportionment. And
just to be clear, it's an apportionment even in relation to North London?
Yes, my lord. Because, contrary to my learned friend submission, there's an existing facility taking waste to landfill, and so some of the waste goes to landfill, some of the waste goes to Great Moor. And
I'm taking out of your course, but just so I understand this, we've only got one North London contract, have we? And that's the Great Moor one. Or am I misremembering?
In the rates, they can take the waste to landfill, or they can take it to Great Moor.
I see.
And But just to remind my lord, what we're saying is what Mr. Mackenzie was doing was he was taking cost centres. So he looks at Calvert, which is the receiving railhead, and apportions the cost on a tonnage basis.
So the cost centre he's looking at is Calvert.
But I think
I may come back to you on this.
I'm very happy to be taken out of turn.
Follow your own course, and I'm sure.
I will seize any opportunity to clarify. I do accept this case is not totally straightforward. I have the handicap of having been in it for 5 years, so there are things that are perhaps obvious to me. The point that we'll come on to now is in relation to manpower costs and why the defendant's case failed on manpower. Yesterday, my learned friend was saying, in the context of the North London cost, well, this is obviously directly incurred costs. But the problem that arose, a rather practical or procedural problem, is that the defendant did not identify costs that were directly incurred. The costs were identified in the way I've just shown, my lord, in the extract from the blown up extract of page 250. We'll look at that in a bit more detail in a moment. In terms of manpower, the second problem is the way in which manpower is presented. So we have a one-line item saying manpower. We didn't know what that referred to, whether that was directly incurred cost or not. There was no attempt, and never has been any attempt by FCC to split out directly incurred manpower costs from overhead type costs. And their case remains. No, it's all directly incurred. Even today, that's their case. And if we can just look at how this was pleaded, just because it sets the context of the conclusions that the judge then came to. So if we look at core bundle, tab 16, page 217. So this is a schedule appended to the particulars of claim drafted by me in August 22. And then under the heading costs directly incurred versus indirectly incurred, we refer to the definition, paragraph 6, definition of third-party income. 7 and 8, we make the point that it's for FCCB to show that costs are directly incurred. And then we make observations about the way the information has been presented, that it's not possible for us to see directly incurred costs. And then at paragraph 13, we make the partial concession, well, the cost of manpower, which is the description we've got, might or not be a cost directly incurred in generating the income. At present, FCCB has simply provided values against this one-word description, together with a rate, in some instances but not others. So if we look at the extract, the blown up extract from the spreadsheet, you'll see there's a rate at brackets 1.56, and we infer that that rate has been multiplied by tons of waste to generate these sums of money. That's what we were given as the cost, at a very high level summary of manpower. And for all practical purposes, that is how the situation remained until trial. If we just, for completeness, look at tab 31, which is the response to my schedule 3 of the particulars of claim, page 611. This is the re-amended Schedule D3, so it's the fourth iteration. The defendant asserted at paragraph 2b on page 611, each of the heads of cost listed in Appendix A were heads of cost directly incurred. So that's a sort of bare assertion. And then in terms of how they respond to the passage I took the court to just now, if we turn up page 618, so they reproduce the heading cost directly incurred versus indirectly incurred. At paragraph 18, they make the assertion that the costs that FCCB seeks to deduct have all been directly incurred. And then in terms of manpower, we have this passage at paragraph 20. It's noted that BC acknowledges the cost of manpower might be directly incurred, otherwise paragraphs 12 and 13 are denied. The costs deducting were directly incurred, including manpower. And then it says FCCB has provided further explanation of the TPI review at the meeting between the parties and in associated correspondence. And this is the case they went to trial on, that they provided explanation in meetings. The meetings were not attended by lawyers. I mean, they were just attempts to try and ascertain the values and so on. And it's then necessary to see how the court dealt with it in the trial. So the judgment at tab 10 of the court. And then the passage starts at page 129. Heading is at paragraph 247. In due course, I would invite, when an opportunity presents itself, I'd invite the court to read that passage in full. But the short point is, the court, like us, acknowledged that there may well be manpower costs that are properly characterised as directly incurred. The difficulty is that FCCB has simply asserted manpower costs. It hasn't done any kind of calculation of the directly incurred bit or explained how that's been done. And it obviously includes costs that are not directly incurred. So the entire manpower claim was lost for lack of any calculation corresponding to the requirements of the contract. But of course, as the court's heard, FCCB's case today, yesterday, is all of these costs are directly incurred. So we're not in any different situation. The court will also note from the terms of paragraph 252 of the judgment that after the judgment was handed down in draft, my learned friend made further submissions about manpower costs, again making the point that, well, some of these manpower costs are clearly directly incurred. But they had, even then, they still hadn't done any kind of exercise of identifying, well, what are those costs so that they can be taken into account. That paragraph 252 took into account the post-draft judgment further submissions. Paragraph 252D, the court said, no time had Buckinghamshire Council ever conceded that manpower costs were direct costs, and moreover it made clear in its opening submissions that FCC had chosen to organise its costs into these categories, that BC was not in a position to unravel them to try and work out which might fall into which category, and in the circumstances the burden was on FCC to demonstrate that all of the various component parts of the heads of costs into which it has grouped things are costs that were directly incurred. And then the court goes on to point out, well, this was all at FCC's hand. And then at F, again, is referring to the post-draft judgment submissions. In reality, what FCC is inviting me to do, having considered my judgment in draft, is to reconsider my conclusion that it would be not proper to allow FCC to have the opportunity to advance this intermediate case, in other words, where some of the costs are identified as directly incurred. Indeed, in its responsive submissions on this point, it submitted the fairest course would be to determine the question of whether manpower costs are deductible at the later trial, 2026. And he's against them. So the conclusions you get from that are there obviously were directly incurred manpower costs. They were never identified. The judge could not possibly be expected to identify them in his judgment. We were not able to identify them. FCCB throughout had adopted what the court refers to as an all-or-nothing approach, and it failed. And the result is they've suffered losses. They've incurred directly incurred costs, but they haven't been able to deduct them because they've not been able to identify them. So there's nothing for the Court of Appeal to do here. There is could not conceivably be any appeal against that approach, nothing to do with the construction of the contract, purely to do with the formulation of the claim. And it is significant. It's obviously a relatively large item. So that's manpower costs. And then finally, in terms of costs, there was a mention yesterday about the audited accounts. As per Mr. Mackenzie's statement, what we've seen is management accounts which are by cost centre. We have obviously looked at publicly available accounts information. It is quite impossible to relate that to the data that we've been given, unsurprisingly, because it's arranged completely differently. So if I can now just briefly say something about the history of the litigation.
Yeah, just before you do, just following my red herring for a moment so I understand. If we go to the bundle you produced this morning, the second page dealing with North London. And this goes back to the fact I obviously don't properly remember the North London contract. So these are costs that are attributed to a cost centre. I don't know which cost centre is this.
Well, it will presumably be Hendon, which is, I think, where the material is loaded.
Yes.
And Calvert, which is where I think there's an unload element.
And just help me on this. So take Hendon. We know at Hendon, waste is received, and then it's some or all of it, you can tell me, is put on a train to go to Calvert.
Yes, Calvert's servicing the landfill and the Great Moor, I believe.
And so I think Miss Parkin was rather suggesting yesterday, now I may be wrong, well, look, well, she was certainly saying the costs of putting the stuff on the train must be deductible. I don't think you're quarrelling with that in principle.
So
if they were identifiable, if you were putting stuff on the train to go to Calvert, to go to Great Moor, then you wouldn't in principle say that wasn't deductible. You say, well, we can't identify it.
as directly incurred
Yes.
for the purpose of that part of the contract.
No, I follow that.
Yes, subject to, obviously they've won on haulage so far, so.
Yeah, yes.
My lord, I'm loath to interrupt, but you may remember I took you to a paragraph in Mr Mackenzie's witness statement yesterday, which deals expressly with how the North London costs were collated, and it's paragraph 819 of the bundle, which is 579 in the supplemental bundle, and it's not costs allocated to Hendon.
Yes,
So if I could just invite the court to consider paragraph 819 and 820 of Mr Mackenzie's witness statement, which I did take the court to yesterday afternoon.
yes. So it's a Calvert cost centre.
And Calvert is that rail transfer station we were talking about.
So I suppose what I'm just trying to understand is if you take the Calvert transfer station, will it have been doing anything other than processing the North London contract as material going to Great Moor?
My understanding is that it processes landfill and Great Moor. I think there was cross-examination about this, that there was a haul from Calvert to Great Moor, which would be covered by haulage, or there was a haul from Calvert to the landfill site.
Yes, I see. And I'm sorry to waste everyone's time on this, but I'd just like to understand. So under the North London contract, material is taken from Hendon to Calvert. And you say some to Great Moor, some to landfill, and we can't tell which manpower is used for which. Can I just relate that back to the contract so I understand it?
Sorry, my lord, just to be clear, the problem with manpower that I had in mind was, or the approach taken by the court was, well, you have management manpower, which is in the nature of an overhead and is not a marginal cost, is not a variable cost that's dependent on quantity.
No, I follow that. If you had a transfer station that was exclusively doing things in relation to stuff going to Great Moor, then one might say, well, the fact that it's an overhead in relation to that transfer station might not be thought to matter because it's still tied exclusively to Great Moor.
I understand, my lord, yes.
And as I understand it, what you're saying is, well, actually, Calvert isn't exclusively about Great Moor, it's about other landfill at least as well.
Yes.
And can I just relate that back to the contract, showing that I've forgotten what the contract says?
So, the North London contract is tab 10 of the supplementary bundle. The rates, my lord, are at page 384.
Oh, I see. So there's FCC has a landfill site at Calvert.
Yes, my lord. And the evidence at trial was that there was a very slight difference in distance.
But at any rate, Calvert is not being used exclusively to feed Great Moor.
It's an established site. I think it was in the tender documents. I think it was in the bundle. There was reference to Calvert being used
and the North London contract didn't provide for waste to go exclusively to Great Moor. Some of it was to go to landfill.
I think that's right, my lord. I might just want to take instructions, perhaps in shorter German. I mean, it's my learned friends raised it yesterday as this is all exclusively. I mean, the problem that arises is my learned friend is inclined to identify a specific cost and say, well, look, this is direct cost, but that's not how that wasn't the problem that the judge was tackling during the trial.
So I suppose there are two aspects to this. One, does this specific contract, the North London contract, provide for waste potentially to go either to Great Moor or to go to landfill? That's one aspect. The second aspect is, regardless of what this particular contract says, if Calvert was an existing site for landfill, was it or might it also be being used for other contracts with other people?
Yes. I cannot recall what the evidence on that was.
I mean, if on the other hand it were the case that you could say, well, Calvert only existed to service Great Moor, then one might think that all the costs associated with Calvert could be more easily attributed to the arrangements with you.
Well, I understand that, my lord. There's no two ways about it. That Calvert was an existing facility that FCC was already operating. It didn't suddenly stop operating it and change its purpose.
Yeah, I see.
So, my lord, I was just going to briefly take the court to the dispute resolution process today. So, key in the story is the Part 8 proceedings. So, in 2015, FCC was explaining to Buckinghamshire Council about the 3 third-party waste contracts and how, although a higher rate was paid by 2 of the third parties, a reduced rate was paid into the project. And although we didn't take the point immediately, by 2020 there was clearly a dispute between the parties about whether that was the right approach. And we brought the Part 8 proceedings, which were heard in March 21 and resolved in a judgment in October 2021. Now, although there were 3 third-party waste contracts, the specific complaint that we had was the higher gate fee being paid for disposal at Great Moor by 2 of the third parties. That wasn't a problem that arose with Luton, and for that reason Luton didn't feature in that. That wasn't some sort of tactical manoeuvre. It was just that the equivalent problem didn't arise with Luton, where the third party paid exactly the guaranteed rate. Having said that, obviously what the status of the income from Luton is now directly relevant to what we're here for now. In that context, if we can just take out supplementary bundle tab 16, which is the order that was made in October 2021. So it's the order is at page 523 of the supplementary bundle. So at paragraph 1 on page 524, the court made declarations about those 4 contracts, 2 of them with third parties and 2 of them involving FCCR and FCC Waste Services. Then at paragraph 2, in order to assist the parties, the court made the general statement that income received by FCCB or any affiliate in respect of the movement of waste to the facilities for the purpose of treatment and or any other handling of waste for that purpose is income associated with the project, and third-party income is defined. So if an affiliate moves waste, collects waste from the curbside or otherwise handles waste, and brings it to Great Moor, then the income that's generated from that exercise is third-party income. And obviously, Mrs. Justice O'Farrell's decision was a first instance one. Nonetheless, there was no appeal from that judgment, which has stood now and governed the parties' relationship for some years. And we would respectfully invite the court to leave her findings undisturbed, or there would be potential unfairness. There are some specific findings that I would just like the court to note in that context. So, my learned friend made a lot yesterday about the difference between paragraphs 11.4 and 11.5 in the payment in Schedule 15 of the project agreement. And she said that we haven't identified whether third-party income from gate fees paid to affiliates or haulage and so on, which paragraph that falls into. But we said that was all dealt with, that the same issues arose in front of Mrs. Justice O'Farrell. My learned friend also made the point that in the payment there's a reference to gate fee paid to the contractor as opposed to a contractual affiliate. Again, that point was also argued in 2021 and also disposed of. If we turn up the judgment, the discussion begins at supplementary bundle page 505, tab 15. At paragraph 82, the court refers to the fact that the contractor is referred to in the Schedule 15, but the definition of third-party income expressly includes FCCB's affiliates. And she then applies that when resolving these same points.
So specifically, the reference to the contractor's income includes income received by FCCR or FCC Waste Services.
Yes, my lord. And in the context of the payment, where it refers to gate fee received by the contractor, she also resolved that. So we see that at paragraph 88. Sorry, 87 is setting out the FCCB's argument. FCCB at that stage were represented by Roger Stewart, you see, as he then was. Mr. Stewart relies on the formula for calculating the third-party income share in paragraph 11 of Schedule 15 in support of his submission that the authority's entitlement is limited to the specific share of excess gate fee income received by FCCB for the treatment of waste from third parties at the facilities. It's exactly the same argument as my learned friend puts yesterday. However, although the formula in paragraph 11 sets out the steps in the calculations required and the components to be used in such calculations, it does not purport to override the defined terms set out in Appendix A of the project agreement and must be read subject to those express terms. And we respectfully invite the court to take the same approach as did the judge, Susanna Judge Davies. TPWR is described in paragraph 11.4 of Schedule 15 as the excess third-party waste, third-party income derived from gate fee revenue, calculated in accordance with the following formula. The income received by FCC Waste Services from Herts East County Council and from London Waste is not revenue paid at the point of delivery of the waste to the facilities. However, gate fee revenue is not a defined term in the project agreement. Its ordinary and natural meaning is revenue from charges for waste received for treatment or disposal of the facilities. It does not necessarily exclude charges for ancillary services provided for the purpose of delivering the waste to the facilities. Further, the formula set out for the purpose of calculating TPWR includes the actual third-party income as considered above. In the absence of clear words to the contrary, the mere reference to gate fee revenue will not override the references to the defined terms third-party waste and third-party income. In particular, it does not displace the clear and express definition of third-party income in Appendix A. And then at paragraph 89, she refers to 11.4, which refers to the actual third-party income received by the contractor. Again, one of the 2 points made by Melanie yesterday. However, those words must be read against the defined term, third-party income, which explicitly includes income from affiliates as part of the contractor's income. And so, in addition, when the parties went into trial in April 2024, both sides adopted the approach that this income was within paragraph 11.4. And one can see that from the written openings, if it would be helpful to take the court to, but there is no doubt that both parties were proceeding on the basis that they were bound by Mrs. Justice O'Farrell's judgment. And that this income from third-party waste was caught by 11.4, whether it was gate fee income received by FCCB, gate fee income received by affiliates, or other income generated by third-party waste in connection to disposal of waste and treatment. If I can move quickly on to costs directly incurred. If we could firstly take out the definition, which is in core bundle, tab 33. The definitions are Appendix A. I think my learned friend referred to it as Appendix 1. So Appendix A, which starts at page 8.2.
Sorry, is this tab 43 we're looking for?
It was tab 33 of,
33.
of the core bundle, the project agreement.
What page was it?
Page 848, bundle page 848.
So we're on the definition of third-party income.
Yes, my lord.
Oh, yes, sorry.
And we're concerned with the last sentence of the full paragraph. The contractor and or affiliate shall be entitled to deduct from such income the costs directly incurred in generating the income, and then followed by the three provisos. We say the meaning is clear, there's no ambiguity. Costs directly incurred are to be contrasted with indirect or fixed costs. We'll look at the factor matrix briefly. In terms of my learned friend's position, I understood the FCCB to be saying that the judge was in error in applying the ordinary and natural meaning of the word.
I think Ms. Parkin would say that the ordinary and natural meaning was different from what the judge thought it was.
Well, that was what I wasn't quite sure of. But
I mean, at any rate, for our purposes, in a sense, it doesn't matter.
It doesn't
The question is what the ordinary and natural mean might be.
well, I think our point here is, well, the ordinary, the normal and natural meaning of cost directly incurred is clear and should not present any difficulty and is as found by the judge. In terms of my learned friend's alternative interpretation, we do struggle to understand what exactly that is. Before we come to that, if I could just briefly take the court to the cases at the risk of taking up unnecessary time. The only authorities I wanted to refer the court to were the well-known passage at paragraph 15 and following in Arnold and Britton, we could just take it out. The court will. So Ireland and Britain is at tab 6 of the authorities bundle. Paragraph 15. When interpreting a written contract, the court is concerned to identify the intention of the parties by reference to what a reasonable person having all the background knowledge which would have been available to the parties would have understood them to be using the language in the contract to mean. And it does so by focusing on the meaning of the relevant words in their documentary, factual and commercial context. And it lists out the matters to be taken into account. Paragraph 17. Sorry, for the present purpose, it's important to emphasise 7 factors. Paragraph 17. First, the reliance placed in some cases on commercial common sense in surrounding circumstances should not be invoked to undertake the importance of the language of the provision which is to be construed. The exercise of interpreting a provision involves identifying what the parties meant through the eyes of a reasonable reader, and save perhaps in a very unusual case, that meaning is most obviously to be gleaned from the language of the provision. Unlike commercial common sense in the surrounding circumstances, the parties have control over the language they use in a contract. And again, save perhaps in a very unusual case, the parties must have been specifically focusing on the issue covered by the provision when agreeing the wording. Well, we say that, well, that's exactly our situation. The parties have non-contractual documents that are relied upon as factual background, but they have obviously prepared the actual wording of the definition, specifically intending those words to be paramount in importance. They don't go back and amend the non-contractual documents to correspond with what they've agreed. Secondly, paragraph 18, when it comes to considering the centrally relevant words to be interpreted, I accept that the less clear they are, or to put it another way, the worse their drafting, the more ready the court can properly be to depart from their natural meaning. And we say, in our case, that the meaning is clear and there's nothing wrong with the definition of third-party income. Nothing difficult about the wording used, or there's no circularity or infelicitous drafting. 19, again relevant in our case. Third point I should mention is that commercial common sense is not invoked retrospectively. The mere fact that a contractual arrangement, if interpreted according to its natural language, has worked out badly or even disastrously from one of the parties is not a reason for departing from the natural language. Commercial common sense is only relevant to the extent of how matters would or could have been perceived by the parties or by reasonable people in the position of the parties. Well, that's our case. FCC, by all accounts, FCC did not read or understand Appendix A, definition of third-party income. They were not aware that income paid to affiliates would be third-party income. We can see that from the Sinclair slides. That's irrelevant in the sense that it doesn't assist in the construction of the clause. But paragraph 19 is opposite, because the claimant, the defendant's case, the FCCB's case is, this can't be right because look how much money we lose. And we say, well, that's just all irrelevant. The fact that the contract hasn't gone how you thought it would. And secondly, a point I've made more than once, I'm sure, is we, Buckinghamshire Council, didn't know how FCCB or its related companies make their money. We don't have visibility of their commercial arrangements. So much for Arnold and Britain. And then briefly, Wood and Capita, again, seem to us to be relevant at tab 7, well then passage at paragraph 13. Textualism and contextualism are not conflicting paradigms in a battle for exclusive occupation of the field of contractual interpretation. Rather, the lawyer and the judge, when interpreting any contract, can use them as tools to ascertain the objective meaning of the language which the parties have chosen to express their agreement. And then it goes on the judgment goes on, some agreements may be successfully interpreted principally by textual analysis, for example, because of their sophistication and complexity, and because they have been negotiated and prepared with the assistance of skilled professionals. That's our case. This is a highly sophisticated pair of contracting parties, legally advised, drafting an agreement over formulating their contract literally over years, departing from standard wording in order to fashion their own bespoke agreement that suited their needs as they saw them. Then the court goes on, the correct interpretation of other contracts may be achieved by a greater emphasis on the factual matrix. For example, because of their informality, brevity, or the absence of skilled professional assistance. That's obviously not our case. And so we say, well, it's very limited weight, as the court found at first instance, very limited weight can be put on factual matrix. It certainly shouldn't be allowed to trump what the parties actually agreed to. The court then goes on, but negotiators of complex formal contracts may often not achieve a logical and coherent text because of, for example, the conflicting aims of the parties, failure of communication, differing drafting practices or deadlines which require the parties to compromise. There may often, therefore, be provisions in a detailed, professionally drawn contract which lack clarity. So there, notwithstanding the heavy involvement of lawyers and so on, it is necessary. But again, that's not our case. We're not in a case where the definition doesn't make sense or contains some circularity or meaningless provision. It makes perfect sense. And then the third case I was going to refer to is Solutions for North Tyneside. It's at tab 21. To save time, my lord, I don't propose to get it out, just to meet the point that my own friends cited it yesterday. But again,
Mr. Desissaire, wasn't it?
Yes, my lord. It was paragraph 103, and the text that my own friend relied on was very maybe infelicities in drafting and definitions that are circular and so on. But that's just not our case. There's nothing circular about the definition. It works perfectly well. It's not necessary to have resort to factual context in order to understand these words. So far, so straightforward. And we say that when one reviews the judgment, it's obvious that the judge was well aware of the principles and applied them very carefully.
Can you help me on what are the considerations that one should have in mind when asking the question, are costs directly incurred or indirectly incurred, that being the opposite? I mean, plainly, that is the defining characteristic which either allows the expenditure in or takes it out, depending on the answer. Is this a question one needs to look at as an accountant or as a matter of, well, just as a, of course we all know what the words mean. We have a vague idea of what the direct connection is as opposed to an indirect one, but it might be helpful, at least for me, to be able to focus a little more closely than that on how one should actually articulate the dividing line.
In terms of how one articulates the dividing line, we would say that a party can incur costs, as my learned friend described, for example, insurance, to take the example I put to Mr. Mackenzie. But if that cost is simply a general purpose, a general cost of its business, there is a lack of immediacy or relationship between the winning of the income and the incurring of that cost, so that it is not it is incurred, but it is not directly incurred. And direct costs can be contrasted with indirect fixed costs or overhead type costs.
Yeah.
In each case, they are costs that are not marginal costs. They are the costs that you always had. They are indeed necessary, or may be necessary to win the income, but they do not directly arise out of the winning of it.
And one answers that as a sort of well-informed businessman rather than as an accountant would, or?
Well, my background is as a construction lawyer, and in the construction context, obviously FCC is a construction contractor as well as a waste person.
Yes.
I suggested that direct costs are well known in the construction industry. Not in accounting terms, but because in construction one's perpetually looking for reimbursement of cost, and there's argument about direct and indirect.
I mean, in that respect, the judge obviously agrees with you, because he talks about the general understanding and approach which most lawyers, accountants and business people would share. I think Ms. Parkin says, well, it doesn't say direct costs. It says directly incurred.
Yes.
And she says, well, you're effectively reading in direct before costs, so that you're trying to say it's the direct costs directly incurred. Now, does directly incurred mean something different from direct?
Well, I accept that it doesn't say direct costs directly incurred. I suggest that they are synonymous. One is obviously an adverb describing how it's incurred. The other is a shorthand. Direct cost is nothing more or less than a shorthand for costs that you have directly incurred. And one can see it by in considering the examples of what wouldn't be a directly incurred cost, would be something that you already had, a cost that you were already incurring, or was already necessary for a particular general purpose. The learned judge's approach was to look at immediate relationship between the winning of the income and the incurring of the cost. And that approach, I suggest, is sensible and correct, and would be valid whether one looked at directly incurred or direct costs.
I mean, he elaborates on that in paragraph 203, doesn't he? He says immediate relationship in 199, and then in 203 he provides further explanation.
I'm sorry, which paragraph was that?
203.
Yes, thank you.
The judge provides further explanation, as I understand it.
Well, I accept that he's using the term direct costs there. I do acknowledge that the word direct is an adjective as opposed to an adverb, but I suggest that.
But as I understand it, however one gets there, you agree with paragraph 203.
I do, my lord, yes, respectfully. So in the last half of that paragraph, he refers to costs which are not specifically incurred in relation to that activity, but are the general costs. So I think specifically is also helpful in terms of understanding directly incurred.
We're obviously coming to specifically in a moment.
Well, in the context of revised.
Yes. Can I just talk around it for a moment, going back in a sort of way to where we were? If it were the case that FCC identified an individual who spent all his time loading waste onto a train and the waste was going exclusively to Great Moor, that's directly incurred.
Yes, my lord.
If it were the case that you had a transfer station owned by FCC which did nothing at all apart from send third-party waste to Great Moor, would the costs of running the transfer station be directly incurred in generating the income?
Well, the costs of running the transfer station one would have to see, well, what are those costs? So insurance, for example, one would need to see, well, what additional cost is being said to arise out of the operation of that transfer station, which otherwise would not be being incurred.
Well, I mean, let's take the extreme case. You suppose, which obviously isn't the case here, that a transfer station is set up to service material going to Great Moor. That's the only reason it's come into existence.
It's been constructed for
It's been constructed for the purpose, let's say. And then you insure it. Would that be a directly incurred cost of generating the income that's going to come from the waste going to Great Moor?
I would have thought that would have to be, yes. I mean,
Yes, I see.
Our situation is that none of the costs are...
No, I follow that, but I'm just trying to...
I'm making that concession very safely. I don't know.
So it isn't necessarily the case, even on your case, that it would be impossible to include insurance costs or the like, but that would depend on the building being insured existing solely to service Greatmore?
I would put it, my lord, it would depend on a cost being incurred as a direct outcome of winning that income. So in terms of the insurance, if FCC Group simply has a block insurance policy that just covers its buildings, even if the number of buildings ebbs and flows from year to year, it's difficult to see how that would. They're incurring a cost, but there's no direct cost. If when they build the hypothetical waste transfer station, the insurer writes and says that your premium is now going up because you've built this new facility, that's difficult to see why that wouldn't be a cost directly incurred in winning that income.
Yes, I see.
And the problem is, I mean, the real issue is in relation to manpower, where the contractor's case is, in terms of the issues that they lost, is the strongest, because obviously there will be some relationship between winning income or the winning of income and what labour resources you're going to need. But they never did that analysis. My lord's questions I feel are more directed towards the overhead type cost. And I suppose there's a question there, well, could you have something that is both an overhead, but is also directly incurred? And the answer is, well, yes, if it's a local overhead that is specifically for the generation of that income.
So you can't rule something out just by saying it's an overhead.
But it depends. I think
it all depends on what the overhead is and what part of the business it's devoted to.
I think I accept that, my lord. I think the word overhead has, in this context, two potential meanings. There is overhead type costs such as lighting and insurance and so on. So that's a sort of informal meaning. But in our context, what we're saying is, well, you've got your general business costs as opposed to those variable costs. So overhead is meaning different things in different contexts.
Yeah.
So I think the point I've already made was just to emphasise in the context of this discussion, the contractor did win on directly incurred costs in the context of haulage, and we conceded that. And they would have won on manpower had they identified directly incurred manpower costs. All of the other costs are clearly not directly incurred, and they're nothing like the hypothetical example we've just been discussing. Obviously, the next most significant element is going to be the divisional overhead and group overhead and so on. And we say that all that puts into context the principal argument, which is this is a very bad contract for FCC. This can't be the correct meaning because it's not balanced, it's not incentivising us and so on. But when one thinks about what the majority of these costs are, haulage they've won on, so that argument is irrelevant. Manpower they would have won on had they formulated, they would have won in part at least. And then the next big item is overhead, and we're saying, well, you're getting overhead. You're getting overhead through the base case and all the rest of it, and that's clearly not directly incurred.
So directly incurred is about marginal cost, and because it's about marginal cost, you cannot apportion.
Yes, my lord. I think the way I would put it is it's about the additional cost or marginal cost incurred, and therefore a cost that you already had cannot then be allocated on an apportionment basis and called directly incurred. The point I was trying to make is when one considers what the costs are that they're trying to deduct, they've won on haulage, they would have won on manpower if they presented differently. Overhead is obviously not a loss as such. But in that context, and when we then look at the factual matrix, it's taking you absolutely nowhere. The premise of their case is the factual matrix would be a balanced contract that we would be incentivised to win third-party income. It's just turned out like this for a range of reasons that are nothing to do with the points that they seek to make. I must just very quickly look at the factor matrix documents. As I understand it, the documents at tabs 30 to 33 in the supplementary bundle. Starting at tab 30, which is page 698. So this is perhaps potentially the most significant because it is in fact our document and it's specific to the project. It refers to the contractor being incentivised. So I think the relevant passage is at 718. Paragraph 21313C refers to incentivised. Any income sharing proposal should recognise the Council's risk position and have regard to state aid implications. Note that it's recognised that whilst the Council would expect to benefit from income generated by the facility on a basis consistent with the risks borne by the Council as funder, clearly the operator also needs to be incentivised and reap the benefits of its efforts. And we say, well, you've got two very high-level statements there, which cannot provide anything more than the most vague assistance in interpreting this definition. The first statement is that it's necessary for these arrangements to have regard to the risk that the council's taking and state aid implications. In other words, we, as a tax-funded state institution, cannot be supporting FCC. That immediately would explain why you have these very rigorous provisions about specifically and solely and so on. FCC's business is moving waste around, disposing of it for third parties. We cannot be seen to be improving their margin, paying for their overhead and so on, subsidising their operations. And then the second sentence is, well, they need to be incentivised. I've already explained, well, we saw that as they're getting the 25% of the third party income. But the point is, those two objectives conflict with one another because one of them is about waving a carrot at the contractor, the operator, whereas the other one is avoiding being too generous to the contractor. So they pull in different directions, and you can't really get anything in terms of what do the parties actually agree. So that's that document. Tab 31 is the SOPSI, I think it's called. And this refers to the need for commercially balanced contracts at page 801. Obviously, it doesn't make specific provision, as the previous document did, for the fact that we're bearing the risk, and I don't believe it refers to the need to have regard to state aid. I've made at page 281.
Sorry.
Page 281, the last page in the extract. So it's 820. I beg your pardon. I was in the internal.
I see. Internal.
So,
Yeah.
Paragraph 35.1.1. PFI contracts are structured so the private sector is responsible for delivery of services on time, on budget, and according to specification. And it goes through the key elements of such structuring. And then there's a footnote. Footnote is to the second bullet point. Second bullet point, multiple stakeholders, both shareholders and senior lenders, are financially incentivised to manage and resolve difficulties which may arise within projects since their returns are dependent on the successful delivery of the project. rather than the balance sheet of the contractor. Footnote, this guidance assumes the project is being financed on a project finance basis. If this is not the case, different principles may apply. And we said, well, different principles did apply, and my client obviously expected to get a lot of money out of this project and that not be seen to be providing state aid. Finally, the document at tab 32, page 821, the Waste Infrastructure and Delivery Programme Residual Waste Procurement Pack, Payment Mechanism Principles. I think my learned friend relies on the text at 839, headed, on the page headed third-party income. Sets out the purpose, and then 262. The third-party income sharing mechanism should be structured to allow the authority to share in net revenues from specific process outputs. The last sentence, the revenues shared should be net of additional marginal costs incurred by the contractor. There should be no downside risk to the authority. The trouble with all of these terms is that they are vague and high level, and although the phrase marginal cost is used in the draft payment document at the following tab, that's not in fact the phrase that the parties used. So it's very odd to suggest that, well, we should try and construe the clause so as to correspond with guidance that was prepared for a standard form of document that we've not in fact adopted, or that we've made bespoke amendments to. If we turn over to page 841, the recommendation is that any income not included in the base case financial model that is subject to sharing should be shared after netting off additional marginal costs.
Sorry, I've lost you.
I beg your pardon. I'm in tab 32.
Yeah, on 841.
841. We're in section 263.
Oh, I see. I'm reading the wrong bit. Yes, I see. Yeah, I see, yes.
Top of 841. Any income not included in the base case financial model that is subject to sharing should be shared after netting off additional marginal costs, i.e. those not shown in the model, incurred by the contractor in developing the additional income. Again, I mean, it's in circumstances where the parties dropped the reference to marginal costs and have used different phrasing, it's difficult to see, well, what further assistance does one get from seeing this document, which obviously hasn't been amended by the parties because it didn't form part of their contract. And the way the judge dealt with this in suggesting that, well, obviously one looks at the extent to which the parties have departed from the standard wording. And as they depart, obviously less weight can be put on standard guidance materials. The reference to marginal costs itself doesn't really help my learned friend, because obviously the costs you're seeking to rely upon have not been identified.
The word marginal of itself seems to favour you, but I suppose it says here, i.e. those not shown in the model, which might mean something different.
Well, I was going to suggest that that bit in brackets is deeply ambiguous, because it could mean this is what we mean by additional marginal costs, or it could mean that those not shown in the model that are additional marginal costs. The words id est are capable of two different meanings in the context. But we say, but my lord, the reference to what's in the model, when we then come to look at the definition, when looking at the proviso, that's spelt out in proviso B, which deals with costs that are not in the base case. Proviso A is the cost of winning income that's not modelled. So that goes that's a completely different requirement. Directly incurred is also a different requirement, and proviso C is different. So the word, whatever the correct meaning of those not shown in the model, they can't possibly be read as striking through provisos A and C and directly incurred and so on. What seems to have happened is the parties had the template and this guidance, and they've decided to modify it to suit their purposes, possibly because of the concern about state aid, possibly because the council was paying for all of this, possibly because of experience with these sorts of waste companies who find ways to reduce TPI share in various ways. And then, my Lord, just for completeness, at tab 33 we have the draft PAYMEC. 845 is the draft definition of third-party income. My learned friend's submission was that it was always going to be necessary to amend this definition. Looking at it now, what appears to have happened is not only was it amended, but it was moved from the PAYMEC, which is obviously where it lived, to Appendix A of the project agreement. So its natural habitat, according to this document, is with the rest of the payment mechanism. But for whatever reason, the parties put it into the main body, or the appendix to the main body. And obviously, one can see at a glance the significant changes: introduction of the reference to affiliates, introduction of the word directly incurred, and the expanded the three provisos. And we say, as a matter of construction, well, obviously, one must give effect to the wording that the parties have actually agreed. In priority over more general comments in factual background that are not incorporated into the contract. So, my Lord, there's only one other point I wish to deal with on directly incurred. We rely on the reasoning of the judge, which we say cannot be faulted, and all the practical considerations that he refers to. In addition, the practical considerations that he doesn't necessarily refer to, but which arose, which was the immense difficulty of reviewing costs if they are dealt with on this apportionment basis. I've already said one has to look at the entire cost collection, and secondly, the apportionment exercise. So, for example, to take divisional overhead, if we want to audit that or check that those costs are incurred, we have to look at the entire cost and the apportionment exercise, as opposed to the much simpler exercise of, well, what costs actually relate to winning this income rate directly. Well, the final point I wanted to make on directly incurred was just this repeated reference to scaling up. As I understood it, my learned friend's case is that the judge, in error, applied this requirement that there be scaling up in order to incur costs. That's not what he says. He deals with this point at his judgment at tab 10 of the core bundle, at page 123. So he's dealing with FCC's, obviously all of the passage from 206 to 210 is of great assistance. But at 207 he says, FCC emphasises very strongly that it would offend commercial common sense for this provision to be interpreted so that the overhead or other indirect costs which it incurs cannot be deducted from TPI. It submits that this is especially so if those costs might be so high that not only would its 25% profit share be wiped out, but it will also make an overall loss, potentially a very substantial one. So here is where he comes on to this point about scaling up. It's not a test for what costs can be deducted. He's simply responding to or disposing of FCC's argument that it's making losses. As BC submits, paragraph 208, there's an important and obvious difference between direct and indirect costs. The former are costs incurred directly in order to generate the income in question, whereas the latter are costs incurred by the business as a whole, and are by definition incurred whether or not any particular or specific income is generated. Thus, the extent to which FCC would suffer a true loss in such circumstances, as opposed to the loss of an opportunity to make a contribution to indirect costs, would depend on a number of factors, which might vary considerably at any particular time. So, pausing there, repeat my comment. We obviously didn't know how FCC made its arrangements. So, when we were going into the PA, we thought this was all extremely satisfactory. Only some years later, FCC raised these problems. But then the judge makes the reference to scaling out. As indicated, he's disposing of an argument about FCC making losses. Unless the FCC had actually scaled up its costs of operating a particular facility or service in order to deal with the TPW in question, it would not have incurred any actual excess expenditure on these fixed costs. If it was unable to recover a proportion of these fixed costs from BC, then it would of course have to recover them from existing income. However, that is not the same as saying that it would make a loss. In such a case as the present, that would also depend on whether, and if so, to what extent FCC had already recovered some or all of its fixed costs through the guaranteed income. I suppose indirectly, His Lordship was addressing the proposition put by my Lord just moments ago. Or what if there is the construction of a specific facility? Would that be directly incurred? And I conceded that it probably would be. But the point the judge is making, the learned judge was making here, is there's no loss being suffered unless an overhead cost has been additionally incurred, but nonetheless doesn't satisfy the directly incurred requirement. It's obviously a hypothetical scenario. But it's the beginning and end of FCC's case that we make huge losses on this reading, and the answer is they don't, for all the reasons I've already given.
And I suppose you'd say even if they do, that's irrelevant. I mean, we have to construe the language we find, and the way it works out in practice is obviously future and uncertain at the date when the contract is entered into, and how it pans out in the future is only experience will tell.
That's absolutely right, my lord. If I may say so, if I can come back to my point about haulage and the discussion we were having about the Amersham and High Heavens, we're paying for facilities to deal with third-party waste and to take that waste to Greatmoor. In the event FCC got these third-party waste contracts and used the Hendon Railhead and Waterdale and Kingsway transfer station, and we say that they say, well, that money we get for dealing with third-party waste at High Heavens, that's our money, whether we use that or not. That's just bunts, for want of a better expression, that we get to keep. And if we did nothing at all, we would still get that money. And we say, well, that's right, although bear in mind you've guaranteed £600 million worth of third-party waste, so you're not going to do nothing at all, or if you do, you're not going to make the guarantee. But secondly, we say, well, that cuts both ways. You can do nothing, or you can get the waste in some other permutation. There's a limit to what's going to happen. There's only so much capacity for third-party waste, approximately 200,000 tonnes a year. It's got to come within a geographically proximate location. So it's going to be, if it's not coming to High Heavens, it'll be a transfer station at a similar distance away. And we say, well, whether at the end of the 30-odd year period, FCC has made a lot of money or made losses, no one will know that. That can't be taken into account in construing these provisions. But we say, yes, there is potential for them to make a lot of money if they do nothing at all, but nonetheless make the guarantee. But as we saw it, they were committing to this huge quantity of third-party waste income, which would require them to arrange things such that a lot was delivered to Greatmoor one way or the other. And we're paying for that through the base case, and that's what we're expecting to cover. And if a ton of waste, instead of coming from High Heavens, goes from Kingsway or the rail link, the cost is much the same for practical purposes, and they're not making any loss. I would add that obviously on the case as found by the judge, the present outcome is that they are making a huge windfall from the third-party waste haulage costs that we do pay to FCCR, but that is not in fact being used because they're not using High Heavens for third-party waste. So that was dealing with my Lord's point about what if if they make a loss, it's irrelevant. We agree with that, and we emphasise that we don't know enough, and never knew enough about FCC's arrangements to be able to predict when they would make a loss or profit, or what they exactly how they had prepared their tender, or what overhead they added, and so on. If I can very briefly deal with Proviso A, if we could just look at how the judge dealt with it. So Proviso A requires that the costs to be taken into account are specifically and solely related to the generation of third-party income additional to that modelled in the base case. And our case at trial and on appeal is the requirement for specifically and solely is quite explicit and potentially onerous for FCC, that costs that are incurred for a mixture of purposes will not satisfy Proviso A. And in this context, the mixture of purposes could be a cost that is partly incurred in order to make the guaranteed income. That would fail Proviso A. Or a cost that is partly incurred as part of FCC's general business. And one could see a rationale for that in the requirement that we're not seen to be providing state aid to the contractor. But again, I mean, our understanding when we enter into the PA is we're joining forces with a huge waste disposal business, international business. What we're not doing is subsidising that business. So, as I say, we see specifically solely, the requirement for specific solely is excluding costs of those two types. And as we saw with Ms. Sinclair's slides, it was anticipated that there would be a gate fee paid by third parties above the guaranteed gate fee. But there would be no additional cost in those circumstances. So if a tonne of waste, the guaranteed price is I think £77, but the rate paid by one of the third parties is either £89 or £90. The additional income is the difference between those two, so 12 or 13 pounds. But there's no additional cost involved. The tonne of waste coming to Greatmore and being disposed of, being turned into energy, that cost hasn't changed just because the third party is paying more money. So we say, for the purpose of Proviso A, what they've got to do is get waste in sufficient quantities to Greatmore. If the rates for disposal at Greatmore paid are above the guarantee, on the face of it, there is no cost involved that isn't simply the cost of honouring the guarantee. And then secondly, if what they're doing is their ordinary FCC business, such costs aren't specifically and solely related to the generation of additional TPI. So that was our case, and the judge disposed of Proviso A, starting at paragraph 211. And with great respect to the very experienced learned judge, we do not quite understand how he disposed of that part of our case. I should point out my learned friend's suggestion in her consolidated skeleton is that the judge's reasoning on Proviso A is not consistent with his decision on direct costs. And that's paragraph 56 of my learned friend's composite skeleton. Yesterday, in her submission, she said that the first instance judge had upheld her case, that the costs were specifically and solely incurred. Well, it's correct that the judge found that they satisfied Proviso A, but nowhere in the passage headed Proviso A, starting at paragraph 211, so far as I can see, nowhere does the judge address the requirement that the cost be specifically and solely incurred for that purpose. What he does deal with in those 9 or so paragraphs is a question of what's meant by third-party income additional to that modelled in the base case. That's the whole passage appears to be directed at that. So he says, paragraph 213, he sets out our contention. He says that BC contends it's only cost specifically and solely related to the generation of TPI additional to those figures for commercial income. So the commercial income is the reference to 608 million, which refers to third-party waste income and power income. Well, that's obviously correct. On this basis, it contends that FCC has to establish a stringent causal requirement.
Causal, not casual.
I'm so sorry. Causal requirement. Thank you, my lord. I.e., that in relation to TPI from TPW, the costs have to be specifically and solely related to generating income above and beyond what is guaranteed income from that source. So that does reflect our case that, well, if all they're doing is getting that waste in and the third party is paying a higher rate, well, that obviously doesn't satisfy proviso A, because there's no additional work just because the rate is higher. And then my lord states, in contrast, FCC contends that the only TPI income modelled in the base case as far as TPW is concerned is the guaranteed figure for commercial revenue. And although not appearing explicitly in the base case, that is plainly only gate fee revenue, as stated expressly in the definition of guaranteed TPW TPI. It follows that income from TPW additional to gate fee revenue falls within this proviso, and hence so do costs specifically and solely related. So that comment has to be read in the light of Mr. Justice O'Farrell's evaluation that the reference to gate fee revenue was apt to cover other revenue from getting waste to Greatmore. I think in fairness to Judge Davies, we didn't take the court specifically to that paragraph 88 of Mr. Justice O'Farrell's decision. The lacuna, the gap in his lordship's reasoning with respect to him is that he says, and hence so do costs specifically and solely related to the generation of other sources of TPI. But our point is that the defendant, FCCB, still has to demonstrate that the costs are indeed specifically and solely related to that generation. So to take a very obvious example, head office overhead is not such a cost. It's not specifically and solely related to the generation of TPI for this project. It's a general business cost.
I mean, in a sense, your case would be as strong if you omitted the words additional to that modelled in the base case. You would be left with specifically and solely related to the generation of third-party income. And you say overhead costs are not specifically and solely related to the generation of third-party income.
For that purpose, I accept that, my lord. Agreed. The point I'm making is where they have a cost that is necessary in order to make the guarantee, they cannot deduct that cost against excess TPI. Because they had that cost making the guarantee, that was a cost they were going to need to incur.
Yes, I see.
So, for example, if they bring waste or operate a waste transfer station, or whatever it is they're doing in order to make the guarantee, they can't. Whereas what we saw from Ms. Sinclair's slides is that they were trying to apply all their costs to the fat, as it were. And our case is, well, no, you always had those costs. So if North London paid £50 rather than £89, these costs would be exactly the same. All that's going up and down is the income. So, as indicated, the court's conclusion appears to be limited to what income is being referred to, and he says he concludes at 218. In my judgment, FCC's interpretation is more compelling than BC's interpretation on this point. On BC's interpretation, if all that modelled means is that an amount is included in the base case for TPI from TPW without any indication of the source of that income, then if the actual TPI from TPW exceeded the guaranteed amount, it would be very difficult, if not impossible, to identify which costs were specifically and solely related to the generation of additional income. Thus, this proviso would have the practical effect that no costs related to the generation of TPI from TPW could ever be deducted against TPI for the purpose of ascertaining excess TPI. I regret I don't fully understand what the court's concluding there. I think that there is an issue as to does one simply look at the financial value and compare that with the income being generated. The point we're making, I hope, is a more practical one, which is if they are incurring costs in order to make the guaranteed gate fee revenue, then that excludes those costs from proviso A. But in addition, costs that are part of their general business are also excluded in the same way that costs that are not directly incurred are excluded. And the most obvious example is the overhead. I think the court has my point that they have overheading, winning 600 million of third-party waste. That overhead's not going up simply because higher rates are being paid or other income is being won. But as things stand, the judge appears to have held, insofar as he has dealt with it, he appears to have held that all of these costs satisfy proviso A, and we say that can't be right. So, my Lord, the court indicated that I might be permitted a reply on my appeal, which concerns haulage. So, for that reason, I propose now to turn to Luton income and come back to haulage later this afternoon, if that's convenient.
Yes, so just to be clear, that's what you say about proviso A. Anything to say about the other provisos in the context of deductible costs?
Not in relation to those, not in relation to the court's findings. They are relevant to our case on haulage. Which
yes,
is
I find.
Yes. If I can briefly deal with Luton, which I anticipate will take me to 1 o'clock, and then I'll come back to tackle haulage after lunch, and should be well within time. So I've got 4 headings against Luton: some background preliminary points, provisions of the project agreement, the approach taken by Mrs. Justice O'Farrell in the Part 8 proceedings, and the approach taken by the court. So in terms of background, my learned friend made repeated reference to the Luton contract as having been made in 2004, which is agreed. But obviously what we're concerned with is a contract negotiated by FCC after the project agreement, which specifically provided for the disposal of waste at Greatmoor. It was a variation. It wasn't part of a public, as far as we know, it wasn't part of a public procurement process. It was a specific negotiation of an existing contract by FCC by reference to Greatmoor. If we can just take out Miss Sinclair's helpful slide summary at 917 as a supplementary bundle, tab 46. So page 919, she summarises the provisions of the variation. We didn't have the contract obviously at the stage. Variation to an existing contract to allow for the diversion of waste from landfill. And then at page 921, she shows the mass of it. And as outlined yesterday, the fee that's to be paid by the third party for disposal matches precisely the guaranteed fee calculated on a per tonne basis. So that's £66 per tonne of September 2010 is indexed up to £75.97. And the arrangement that FCCR has now made with Luton in the light of the project agreement and the availability of Greatmoor is that Luton will pay the guaranteed rate, which we see from the other two contracts, appears to be considerably below market rate. And any margin recovery of overhead and so on is, in Ms. Sinclair's words, captured in the wider contract. In other words, the unitary charge will cover the profit element. But of course, it's FCC's case that the unitary charge isn't third-party income that's to be shared with us. And we say, well, that's a surprising result if FCCR can simply price their contract in such a way that that they're providing a below-market disposal rate, less than the two other third parties are prepared to pay by a considerable margin. But they make their profit elsewhere, and that would be a surprising outcome. In terms of the specifics of that, if I can just tell my lord the figures, so they're all in my learned friend's consolidated skeleton. The income from the unitary charge is just over £13 million. That is to say, income over the duration of this Luton contract has varied for such waste as gone to Greatmore. So it's much more than 13 million for all of the waste. But the income from Luton waste coming to Greatmore as part of the unitary charge is 13 million. The reference for that is paragraph 3.b of my learned friend's consolidated skeleton. And the costs that are alleged by FCC, which are to be the subject of a trial next year, the costs of winning that income, including overhead and everything conceivable, is said to be 8.7 million. And that figure is at footnote 4 of my learned friend's consolidated skeleton. And the difference...
Sorry, 8.7 million.
Yes, my lord. 8732,153. The difference between those figures is 4.3 million. So the margin as a percentage of cost is 49%. Yes, so 4.3 compared to a cost of 8.7 is 49%. And we say this is an immensely profitable contract, but where we get none of that, even though we've paid for the disposal facility. And that's a surprising outcome if that's really how this works. That FCC can simply arrange things so that all the profit goes up in TPI. The more obvious explanations, well, of course, this is TPI because it's moving waste to Greatmore. Now, just to be absolutely clear, what we are claiming, we are already recovering the disposal bit. That's just the guarantee, so that there's no profit there. That just goes into FCC's coffers because they keep anything up to the guarantee. The figures that I've just given, my lord, the income figures, it's the unitary charge calculated per tonne times by the tonnage of waste coming to Greatmore. I think my learned friend suggested that was 44% of all of the waste. So if those rates were extrapolated, because this is an apportionment exercise, they're presumably making a profit of over twice what the figures I've been given. But that's obviously on waste, including waste that is not coming to Greatmore, which we are not claiming for. And again, we're obviously not claiming anything under the original Luton contract from 2004. In terms of the terms of the project agreement and the definition of third-party income, the relevant phrases will turn up Mrs. Justice O'Farrell's judgment, so we can see how she dealt with these points. But
So should we be looking at that?
yes, ma'am. Her judgment is tab 15 of the supplementary one. So Luton contract was not part of the Part 8 proceedings for the reasons I've already explained. And she addresses the definition at paragraph 84, bundle page 506. The type of income within scope is income from third parties associated with the project. As Mr. Mortz admits, that is a broad description. The project comprises the provision of waste management services to the authority, including the construction of facilities, the satisfaction of the requirements in the specification. But the income referred to as third-party income is deliberately stated to extend beyond that derived from FCCB's performance of its contractual obligations. The natural and ordinary meaning of the word associated with the project indicates that the definition is concerned with income from a wide range of activities related to the availability of the facilities. It is not confined to income payable only from the activities of waste treatment or disposal after waste arrives at the facilities. No doubt such income is included, but it is capable of extending to income from ancillary activities of collecting waste at a site remote from the facilities and transporting it to the facilities for the purpose of treatment and disposal. Well, that is what FCCR did under the Luton contract. My learned friend makes reference to the fact that they also did some construction work. That was for Kingsway Transfer Station, which was used to transfer waste to Greatmoor and other venues. 85, the definition of third-party income expressly includes income derived from third-party waste. Third-party waste is defined as all waste received at the facilities other than contract waste. The definition could have stated that it was limited to income generated from the time at which waste arrived at the facilities, or income generated directly by the treatment and disposal processes at the facilities provided by FCCB. It does not do so. The natural and ordinary meaning of income derived from third-party waste is that it extends to all income arising from waste that is ultimately received at the facilities, regardless of the point in time at which the sums from which the income is derived becomes payable. So we say, well, where unitary charge is paid on waste that is collected by FCCR or sites that are operated by FCCR and then taken to Greatmoor, that's plainly squarely within the definition, the reference to income derived from third-party waste. In other words, all income arising from waste that is ultimately received at the facilities. And then, as we've seen, the learned judge deals with reference to gate fee and contractor and so on. My learned friend said yesterday that Mrs. Justice O'Farrell did not consider contracts of the same type as Luton, but as indicated earlier today, that she made a general declaration, which I took the court to at page 524. So we say if FCCR is getting income from collecting, assembling, bulking up, moving third-party waste to Greatmoor, that is all third-party income, precisely as it is for the same activities for the other two third-party waste contracts. Moreover, if Buckinghamshire Council were denied this income, that outcome would be inconsistent with Mrs. Justice O'Farrell's judgment. Just while we're looking at the judgment, we could just see paragraph 82.
Sorry, did you say 82?
Yes, my lord, but I now think I have, in fact, the wrong reference. I meant 92, I'm so sorry.
Yep.
Page 507. So one of the issues that Mrs. Justice O'Farrell had to decide was whether third-party waste or income from third-party waste could arise before the waste had arrived at the facilities in circumstances where the definition refers to waste that is that is disposed of at Greatmoor. And our case, which was upheld, was, well, waste before it gets to Greatmoor is still third-party waste, if that is ultimately where it goes. And income from such waste is third-party income. And disposing of that argument, Mrs. Justice O'Farrell said at paragraph 92, FCCB contends that inclusion in the third-party income definition of income derived from waste before it is received at the facility could give rise to uncertainty as to when waste is or is not third-party waste. And it's the next sentence I wanted to draw the court's attention to. Examples cited, in other words, examples advanced by Mr. Roger Stewart QC on behalf of FCCB. Examples cited include waste placed in a householder's bin, waste sent to recycling or degraded in transit or diverted from the facilities. But those are all activities that fit much better with what the Luton contract required rather than the two contracts that were in fact before the court. So household rubbish, for example, or waste sent to recycling. And the court then said none of those scenarios pose any difficulty, and her conclusion is, well, where the waste ends up is determinative for the purpose of the PA as to whether it's third-party waste or not. But the reason for citing those examples, for referring to those examples, is that only supports our case that there's nothing in Mrs. Justice O'Farrell's judgment that would suggest that the sort of services provided for Luton should be treated in some different way in circumstances where they involve taking waste from the inhabitants of Luton and bringing it to Greatmoor for disposal and ancillary management services related to that. And in circumstances where, of course, our claim is limited to income from third-party waste and not any other waste. Very briefly dealing with the judge's approach. Judgment is tab 10, paragraph 298. And his lordship cites the passages that we've just been looking at. Now, it was suggested, so he's referring to paragraph 298, the words associated with the project and the reference to income derived from third-party waste. Those are passages in the project agreement quoted by Mrs. Justice O'Farrell, as we saw just now, and which the learned judge adopted and applied here. And we say he was bound to do so in practice and as a matter of law. Yesterday, as I understood it, my learned friend was making 2 points of relevance here. Firstly, that the judge's conclusion was not based on the wording of the project agreement, but it plainly was, as one can see from 298 and 299. Secondly, my learned friend suggested that the judge was applying a manifest unfairness test, or an obvious unfairness test. That is not correct. He was simply, as previously on the cost directly incurred point, what he was doing was seeking to dispose of FCC's arguments about how unfair this would be. So paragraph 308, in the previous paragraph is referred to FCC's case. 308, I must now state my conclusions. I have no doubt that FCC cannot properly deploy the indivisible sum argument as a full defence to their claims, essentially for the reasons advanced by BC as recorded above. On any view, the simple solution adopted by BC provides a sufficient answer to that objection. It may be a rough and ready solution, but it is not manifestly unfair at FCC. And then he explains his reasoning. So that's, as we see it, all he's done is applied the terms of the project agreement and the rationale or explanation of his predecessor, Mrs. Justice O'Farrell, when presented with a similar problem for the other 2 contracts. However, he has to dispose of FCC's complaint, which is that why should they have to share this income with my client, and in circumstances where it covers both handling third-party waste and other activities. And he deals with it set out at 308. And we say that, that the fact that FCCR is paid a unitary charge in this way, yes, we accept that it may be that that is something that's imposed on them by their third party, but nonetheless that's the agreement that they were content to enter into, and it would be anomalous not to then deny us our share of that income, subject obviously to such costs as FCC is able to establish in the trial which is to be heard next year of what costs they've incurred, directly incurred subject to the three provisos. In their written submission and repeated again in oral submission yesterday, section paragraph 82 of the consolidated argument, my learned friend said that the absurdity of our case was further compounded by BC's case on the deductibility of costs. The learned judge did express a view about the deductibility of costs from a provisional view, and obviously we anticipate that the court's ruling on these points may well assist in resolving the outstanding issues. Nonetheless, it's not reasonable to pray and aid our case on costs. It's not neither here nor there. The question of whether Luton unitary charge income is income within the definition of third-party income, namely income associated with the project, is an independent question of our case on what costs can be deducted. And if FCCB is correct that they have each directly incurred costs that satisfy the three provisos, then obviously they will to that extent diminish our share of that income. If not, then the position is otherwise. That's no more than an operation of the agreement. Well, I think that's everything I have to say on Luton. So, the risk of gabbling slightly, I will endeavour to conclude my submissions before lunch. If I can now turn to haulage. And so we're back with provisos B and C.
Yep.
So we've already touched upon the points a number of times. The court obviously upheld the FCCB's right to deduct haulage from the income to be shared. And that was an extremely significant sum of money, so although they only won on one issue, it was financially not insignificant. And we, as I've indicated, we conceded that haulage was indeed directly incurred costs and probably satisfied proviso A. So our argument in relation to haulage was that it didn't satisfy B or C. And the nub of the appeal is, well, how does one interpret proviso C and the reference to the cost of handling or processing third-party waste?
Meaning you're not pressing proviso B.
I'm going to argue both, but the stronger, the clearer argument is proviso C, and the more straightforward one. The considerations are the same. The problem that arises is the context is Mrs. Justice O'Farrell's decision that waste that ends up at Greatmoor for the purpose of the project agreement is still third-party waste. If it doesn't end up in Greatmoor, it isn't. but it can still generate third-party income before it gets there. And we say, on the same approach, the costs of handling such waste before it arrives at Great Moor, including haulage obviously, are the costs of handling third-party waste. Don't need to wait for the waste to get to Great Moor before characterising it thus. The context of it in terms of what our expectations were, what the parties' reasonable expectations were, I've already alluded to. We pay for FCCB via their operating contractor FCCR. We pay for them to deal with third-party waste, including bringing third-party waste to Great Moor. And the relevant line item in the base case, we have these printouts from the base case that pay in the core bundle. Tab 33 is the project agreement. The relevant extracts are page 1045.
Sorry. So that's different from what we were given yesterday.
Yes, my lord. I'm looking. I think different parties have put in different extracts. I may be wrong.
Yes, I see. So, sorry, I wasn't paying proper attention. So which files should I be in?
So I'm in the core bundle at tab 33, which is the bit that has the whole of the project agreement in it.
Yes.
I mean, I've rearranged my files, and I don't know what the core was provided
Yep.
with, so I'm speculating as to how it looks
Yes, I see.
on the bench. But tab 33 of the core bundle, at the very back of that tab.
Yes, I see.
Sorry, I didn't get the page number.
1045, my lord.
Thank you.
And so this is the base case, which is a schedule to the project agreement as a contractual document, and there are various complications to it. There are also various versions of the base case, because when Amersham was omitted, a new version was issued, and there was a delay, so there was a version omitted for that reason. But the relevant point, in principle, is that this is showing operating costs as per the heading at row 97. And row 114 refers to TLS O&M variable haulage. And as indicated yesterday, these figures are in thousands, and therefore reference to 99,000 is in fact 99 million over the term of the contract. And we don't have visibility of the calculation of that sum, or rather we didn't when we were signing the project agreement. We obtained a calculation of it not long before the trial started. That's an immense sum for haulage, and it's obviously far more than the haulage of contract waste, but presumably includes it. But when going into the project agreement, the information we've got is that FCCB has included in the base case something called variable haulage, which on the face of it is far more than would be necessary just for contract waste. And that's not surprising, because they've guaranteed 600 million of third-party waste, which will need to get to Great Moor one way or another. And the contractor's case, upheld by the judge, was the calculation of that sum was waste being transported from High Heavens waste transfer station to Great Moor. of third party and contract waste. It does not cover haulage from other waste transfer stations of third party waste. And the anomaly or potential unfairness that arises is in the event the third-party contracts are sort of to the east of Great Moor rather than to the south, but they're a similar distance away. So they're at Stevenage and Hitchin and Waterdale and Kingsway. And what's happened on the basis of the learned judge's decision is the contractor is allowed to deduct the actual cost of haulage from the routes that the third-party waste has taken, whilst continuing to draw the income for the duration of this contract, including that income that relates to third-party waste haulage between High Heavens and Great Moor, and the compensation for the loss of Amersham. I should quickly make the point, or reference my learned friend's point, that of course these are different FCC entities. So FCC Waste Services is paid haulage income by North London or by Herts, whereas this money is being paid to FCCB and then paid by FCCB to FCCR, who operates the contract. But our point is, well, yes, that's right, they are different FCC entities, but the scheme of the definition of third-party income is that it doesn't make any difference which FCC affiliate is generating the income or incurring the cost. The party's intention was that these affiliates would be treated, in effect, as equivalent to the contractor, i.e. FCCB. So there's some further...
Do we need this fund anymore?
We do not, my lord. Thank you. If we now turn to the supplementary bundle at tab 13, what we have at tab 13, starting at page 478, this is the O&M model, in other words, the spreadsheet setting out anticipated costs plus overhead and profit, created by FCCR to cost up the operation of the facilities and so on. Including the calculation of haulage. And it's the risk of repeating myself, this is not material that we had when we entered into the project agreement. We just had a line item saying commercial haulage, variable haulage. But what we see at 479 is obviously part of a much bigger spreadsheet. We've just put in a single page extract. What we see is a calculation generating rates. So they're doing, the author of the document, working out the distance and the number of times a trip can be made to work out a rate per tonne. If you look at the bottom half of the top half is some assumptions, and then the bottom half is the calculation of the haulage to Great Moor. And the first calculation is from Amersham, it's not, in the event not built, and the second calculation is from High Heavens to Great Moor, referred to as EFW. And the rate per tonne for the latter is £11.57. And obviously this is in September 2010 prices. And a margin is added for overhead and for profit. And that, together with the contract waste, translates into the stupendous sum of money shown in the base case. And the author of this spreadsheet made a statement which is also in the supplementary provision. Tab 17.
Is this going to take a few minutes, or is it a short point? I'm wondering whether to break now.
Let's break now if we understand. I don't think I'm going to take much longer, but we will. But let's
In which case, 2 o'clock.
Otherwise,